Commission would now like to call up Professor Jayne Huckerby.
Thank you to the North Carolina Commission of Inquiry on Torture for the opportunity to provide testimony today. And my comments will focus on three things, the first of which is the international human rights obligations that governed the US government's rendition, detention and interrogation, RDI program. Secondly, how these obligations apply right here to bind authorities in North Carolina. And thirdly, the multiple ways in which the planning, execution, and the failure to investigate the RDI program violated and continue to violate international human rights law. So in turning to the first of these issues, the content or scope of the US obligations under international law, these comprise a series of complementary protections under international human rights law, humanitarian law, refugee and international criminal law, as we've just heard. And these obligations come from both treaties that the US government has ratified, as well as from customary international law, referring to norms that are binding on all nations, whether or not they have been necessarily codified in law. I'm focusing on international human rights law for the purpose of this testimony, and particularly on treaties, human rights treaties that the US government has ratified, of which three are particularly relevant here. The US government is a party to the International Covenant on Civil and Political Rights, the International Convention Against Torture and other forms of cruel, inhuman or degrading treatment or punishment, as well as the Convention on the Elimination of All Forms of Racial Discrimination. When the US government ratifies human rights treaties, including these three in particular, it does tend to condition its consent to them on a number of grounds, including that they need to be implemented consistent with the US federal system, but also that they are not self-executing, meaning they will require implementing legislation to be able to be directly enforced in US courts. And it's important to note, though, these conditions do not affect US international law obligations, although they may have an impact on how these obligations get implemented and enforced domestically. So I'm going to turn to that particular question that has been very much before the Commission yesterday and today, which is, do these human rights treaties that the US government has ratified bind authorities in North Carolina? And the answer is yes. It's a detailed international explanation as to why yes. I'll give a very brief version of that. As a matter of international law, or as a matter of US domestic law, both state and local authorities are required to be bound and are bound by human rights treaties that the US government enters into. Under international law, this happens because the federal state is considered to be a single entity, meaning that when a federal state enters into a human rights treaty, it binds all levels of government, which are then required to comply with those obligations to the extent that the treaty touches upon areas within their competence. And the US government has explicitly recognized that the federal system of government does not exempt state or local officials from complying with these human rights treaties. But in addition to international law rules about binding state and local authorities, under US domestic law, North Carolina is also bound to implement these human rights treaties, and that's pursuant to the Supremacy Clause of the US Constitution, by which these human rights treaties are the supreme law of the land, binding federal executive as well as state and local authorities. That means, again, that under international law, under US domestic law, local and state authorities are required by whatever means needed, administrative, investigative, etc., to ensure compliance with international law. To be even more concrete on this, again, this all means that under international and domestic law, North Carolina could not allow its public airports or infrastructure to be used to commit acts that violate those human rights treaties. That includes torture, conspiracy to torture, as well as a failure to investigate those allegations. So let's turn to this in much more detail. Again, we've had a lot of discussion over the last 2 days about ways in which what has been described as the US detention, rendition, interrogation program infringes international law. But I want to sort of take a much closer look at these questions. It's important to particularly look at the program planning, execution, and again, the failure to investigate and punish. And all these stages engage international obligations of the United States government. What happened to individuals at all stages of the program engages the international responsibility of the United States government. And here I'm referring to the lead up to rendition, and that includes apprehension, kidnapping, treatment of individuals on the tarmacs of foreign airports by CIA rendition teams. US law also applies to, US obligations under human rights treaties also apply to what happened on rendition flights, what happened in secret detention facilities, what happened in interrogations, and also what has happened subsequent. And I want to reiterate a point that was made by Dr. Porterfield yesterday, which is even though we tend to talk about these moments of treatment as quite separate, they were an integrated system that had huge impacts on the mental and physical health of individuals to which they were subject. That has been my experience in interviewing men who were held in the CIA black sites, that this was a whole experience of which the rendition flights were a particularly integral component. All of these elements do engage obligations under human rights treaties, again, the US government has ratified, and by virtue of the sort of limits of time, I am not able to go into every single human rights implication of these activities, but I want to focus particularly on three things. The first is a prohibition on torture and cruel and human degrading treatment or punishment. The second is the transfer, or refoulement, to torture and CIDT. And then finally, on the international norms prohibiting disappearances. So turning to the first of these norms. International law, as we have heard, prohibits torture and cruel, inhuman, or degrading treatment or punishment. This prohibition is absolute and non-derogable under US treaty obligations, meaning that it is a right so fundamental to the international order that it cannot be set aside or suspended or violated under any circumstances. The absolute ban on torture means that from a legal perspective, there is simply no room for discussion about whether torture does or does not work as a legal question. Instead, the United States government is required to prevent, criminalize, prosecute, and punish four things: direct torture, complicity in torture, attempted torture, and aiding and abetting in torture. And that applies whether it's a state actor undertaking the relevant act or a non-state actor acting under the direction or with the consent or acquiescence of a state official. We just heard, and we heard yesterday as well, that outside of the United States, international tribunals have been addressing the ways in which the rendition, detention, and interrogation of men who were transported on flights that originated in North Carolina violate the ban on torture. And I'm happy to go into more detail on those cases, including to answer a question from yesterday about what compensation has been awarded to these men. But as well as not being able to torture, under international human rights law that binds the US government, you can't send someone to be tortured. You can't transfer someone to another jurisdiction or to situations where they may be in danger of torture. Again, to be more concrete, when the US government transferred individuals to the custody of foreign states, as we just heard, for coercive interrogation, they violated this norm. And they're also legally responsible for what happened to those individuals in the custody to which they were then subject. The same is true for rendition to secret CIA custody. It was illegal under US obligations under human rights law. And finally, international human rights law prohibits what we call an enforced disappearance, meaning the deprivation of liberty by a state agent or, again, persons acting with the authorization, support, acquiescence of the state, followed by a refusal to acknowledge that deprivation of liberty, or to conceal their fate, or to not give information about fate and whereabouts. Incommunicado detention in CIA black sites is per se a violation of the prohibition on disappearances under international law. It also constitutes a form of torture. And particularly one thing that very much struck me during my interviews with men who had been held in CIA black sites is one comment by one of these men who said, "I would have rather been in Guantanamo." because at least then I would have known where I was. So what we refer to as an RDI program, as involving EITs, was in fact, and in law, an enforced disappearance and torture program. It was illegal. As we heard very clearly in testimony yesterday from Ms. Pigazzini and Mr. Slahi, there are a number of additional rights that are violated in addition to these broad prohibitions on torture, transfer, torture, and disappearances. These include the right to liberty and security of person, the right to life when the person is killed or threatened to be killed. We heard yesterday too about the use of mock executions in brutal interrogation. The right to identity, the right to a fair trial and to judicial guarantees, the right to know the truth, including the circumstances around your disappearance, the right to family life, which is profoundly restricted when individuals are removed from their homes and from their communities, and the right to privacy. Across all of the human rights treaties that the US government has ratified, there is also an effective right to remedy, including reparation and compensation for the violations that are being committed. This means, again, that the human rights treaties the US government has ratified govern what the government does not only at the relevant period, but also long after the program has ended. And as such, the failure by the US government to investigate and prosecute allegations of human rights abuse itself gives rise to a breach of these treaties by the US government and requires them to give a remedy to victims. It is also important to reiterate, as we have heard to some degree over the last day or so, that as with all of these international obligations, no war, no state of emergency, no imperative reason of national security can justify torture or inhuman degrading treatment or punishment, transfer to that treatment or punishment or torture, or disappearance. Human rights treaties applied during the War on Terror, despite the US government's position that they didn't. And that was a position that was much disputed and since revised in 2014 by the Obama administration. And they continue to apply now in governing and determining what is an appropriate response to the allegations about what occurred between 2001 and 2008. These human rights treaties apply in US territory and to what happened here, including, for example, around authorizations, through the torture memos that we have heard a lot about, trainings of interrogators, use of airports to launch renditions of individuals. But they also applied extraterritorially outside of US physical territory, wherever the US government exercised effective control, such as in CIA black sites, whether they be in Poland or Thailand, but also on rendition aircraft, whether they were in international airspace or in airspace of foreign governments. And again, this is very important to emphasize, because one of the ways in which the US government sought to avoid accountability during the Bush administration was to argue, again incorrectly, that America's human rights treaties did not apply outside of the sovereign territory of the United States. They quite literally, physically stopped at the border. But just as no state, group, or individual is above the law, so can no person be placed outside of it. And acts such as enforced disappearance in CIA black sites or efforts to create human rights-free zones by putting prisons outside of America rather than in the sovereign territory to try and deliberately give a blank check to interrogations that would have been governed by these rules if they're on US soil, tried to do that, and in doing so, they were infringing international human rights law. Finally, I want to turn to the question of how to think about these international obligations when you have multiple types of actors and partnerships involved in the rendition, detention, and interrogation program. As we have heard yesterday and also today, the US government relied on a unique number and types of partnerships, including, for example, partnerships with foreign governments to use airspace to host prisons, but also a number of partnerships with private actors, including companies. And again, under human rights treaties, there's a legal accountability framework that exists for governing these types of arrangements. So under international law, governmental authorities, including those in North Carolina, are liable for the actions that are taken by their own officials that violate rights under the treaties. But the US government is also liable for the actions of individuals or groups that acted under its instruction, control, direction, acquiescence, including these private actors such as companies. And in short, under international human rights law that binds the US government and all of its governmental authorities, a government can't violate rights, but also can't outsource those rights to be violated by private actors, or turn a blind eye when private actors undertake these activities to further rights abuses. And in failing to investigate, prosecute and punish those activities, as well as to prevent them at the time, and to provide a remedy to victims, the US government's rendition, detention, interrogation program implicated profoundly a number of elements of international human rights law. So I look forward to your questions.
Thank you.
Commissioner Freeman.
Thank you very much.
I was curious, you made a comment that there is no legal question about whether torture does or does not work. Why?
Because the prohibition on torture is absolute and non-derogable. It is not justified in any circumstance. So questions, particularly in the United States context, about efficacy of torture were ones that were very much developed as political questions, as strategic questions. They were not legal questions.
Thank you.
Commissioner Goldsmith.
Okay. Professor Huckerby, let me ask you to suppose, I want to ask you about the enforcement, the mechanism for enforcement of these international treaty obligations. Let's suppose that the United States Department of Justice, under its current leadership, declined to prosecute for violations of treaty obligations, or including the Convention Against Treaty or our own federal legislation. Would there be a legal basis for a subdivision of the United States, such as a state or a county, to engage in such prosecution, not only of its own state law, but in enforcement of these international treaty obligations?
So human rights treaties, as I sort of very briefly mentioned, are what we call non-self-executing treaties, which means that they don't get directly enforced in US courts. But having said that, there are other modalities by which these acts that comprise the rendition, detention, interrogation program can effectively be covered by the courts. One way is, in particular, if there are existing state and federal laws that effectively cover the activities that were in these programs. And to make very clear on this, when the US government ratified the Convention Against Torture, it said to the Committee Against Torture, into the UN system, we don't need any more laws. Our existing state and federal rules, for example, governing kidnapping, governing conspiracy to torture, they cover the kinds of conduct that's going to be prohibited by this treaty. They did actually also indicate that they needed to enact, and did enact, a federal extraterritorial statute on torture, but otherwise indicated that the existing set of laws were there. So there is there are these existing rules that can effectively provide a foundation for addressing conduct in the RDI program. And we'll also hear this afternoon about particularly efforts to hold US government officials to account under Alien Tort Statute claims and otherwise as well from Steve Watt from ACLU. And so there are different, there is a matrix through which these rules in effect can be implemented in state and federal courts. There are also increasingly an avenue by which US actions have been scrutinized has been through regional tribunals. In particular, there have been 6 cases filed in the European Court of Human Rights, of which the 3 have been adjudicated, that directly address the treatment of individuals on board flights that originated from North Carolina. And I mentioned those 3 that have been adjudicated most recently were talked about this morning. One was in 2012, which is in the case of El Masri v. Macedonia, and that particularly had addressed, amongst a number of factual circumstances, the transfer of Mr. El Masri on what is referred to as CIA aircraft, N313P, from Macedonia to Afghanistan. In that case, the European Court awarded Mr. al-Masri 60,000 euros in damages. The other two cases that Mr. Mora just mentioned, Zubaida v. Poland and al-Ashiri v. Poland, decided in 2014. Again, these cases addressed the treatment of individuals who were transported on what has been reported as air-operated flights from North Carolina. Mr. Zubaida was awarded 100,000 euros for his treatment in Poland, and the transfer of Polish authorities, Polish authorities sending him to the American government, and then subsequent treatment in black sites. And also, Mr. al-Ashiri was awarded a similar amount. So, outside of the United States, in the European Court, there are also 3 cases that have been submitted to regional bodies, such as the Inter-American Commission on Human Rights and the African Commission on Human People's Rights, that again address the treatment of individuals who were rendered on flights originating in North Carolina, as well as multiple domestic and regional inquiries. So, outside the forums in the United States, there have been a number of attention to these issues and the issues of accountability under human rights law.
Thank you.
Thank you. Commissioner Wilkerson?
My question was a little more direct than that. My question was, under your language, couldn't aero contractors be prosecuted for aiding and abetting torture?
Yes.
Thank you.
Professor Huckerby, I'm hoping I was wondering if you could elaborate a little bit more on that answer, and particularly the role, what international law has to say about private actors, and in what situations private actors can be held accountable for violations of international law.
Thank you. So under international law, and particularly under the Convention Against Torture, CAT, there is a requirement that governmental authorities prevent, investigate, punish, and prosecute both torture, complicity to torture, conspiracy, and aiding and abetting. And that obligation exists with regard to state actors, of course, but also with regard to non-state actors that are acting with the consent, acquiescence, control, direction of the government. So this would be an example of, on the basis of facts that have been reported, where there is an obligation of the government to prosecute and to be held to account with regard to actions of private companies. In addition, there are, under the obligation to protect human rights, there is obligation to, again, to exercise what we call due diligence, to prevent, investigate, and punish acts by private actors. So the Convention Against Torture clearly contemplates the fact that governments may try and outsource acts of torture to private actors in an attempt to evade accountability under international law, and it prohibits that outsourcing.
Question.
Commissioner Crane?
Thank you. Again, another direct question, kind of carrying on what my colleague said. Could U.S. federal employees be prosecuted for aiding and abetting torture?
Yes.
Thank you.
There's also a question from the audience about the War Crimes Act, asking whether or not local and state officials can be held liable under the War Crimes Act.
Yeah, so the War Crimes Act, as you mentioned, is something that's obviously more in the realm of international humanitarian law and the implementation of that, and so my comments have been confined primarily to implementation of human rights norms.
If there are no further questions, please join me in thanking Professor Huckerby.